I think that's kind of how we're bred as litigators, is that if someone punches at you, you want to punch back harder. And as I guess I've gotten older and maybe a little bit wiser, I've learned that doesn't get you anywhere. And it's certainly not what our clients pay us to do. And I think here that if I had escalated the situation, it wouldn't have gone well for my clients.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, this is Trisha Baxter. I am your host of The Defense Never Rests. Today we are changing things up a little bit. We normally do our podcast live. Today we are doing remote Zoom podcast. And, you know, when I initially started this podcast, I thought we would all be doing everything live, but then I figured out we were missing out on a lot of quality guests that did not want to fly to Philadelphia to be on our podcast in person. So we have been working on doing remote ones. And today is our first one, and I'm super excited about that. Joining me today is Oliver Brooks, my partner. Hey, Oliver, how are you?
Morning.
And we have, I think, a really cool episode. It's really about the different personality types. Before I get into that, I just want to say, if you guys are liking what we're doing and you're listening to the podcast, hit subscribe, give us a 5-star rating and a written review if you're so inclined. We also have a video version of the podcast on YouTube, so check it out. We'd love your support. So joining me today are two guests from Alabama, two defense lawyers, both fathers, Southern gentlemen, why they are perfect for this episode. Todd Weston and Jim Patillo, how are you guys?
Good morning.
Doing good. Thanks, Patty.
So I am going to throw this to you, Jim. Tell us briefly what you do, what kind of clients you work for, and the cases that you handle.
So I do all kinds of work insurance related, a lot of commercial liability. I cut my teeth trying a lot of cases on some personal lines car wreck defense. Probably tried 75 cases to date. And now I'm doing a lot of coverage work. I'm assisting in some SIU investigation, doing examinations under oath. And I've kind of developed a niche in some high net worth personal lines work for some carriers that insure high net worth individuals.
Awesome. So you are going to be giving us a lot of great info today about your experiences with personality types.
I hope so.
What about Todd? What about you? What do you do?
Hi, good morning. And first of all, I'm not a Southern gentleman. I'm a Yankee. I'm a Yankee transplant down here from Chicago.
Perfect.
You sound like a Southern gentleman to me.
Okay, I just married a Southern belle. That's how I ended up down here.
Hey, me too.
But thanks for having us on. Like Jim, our firm, we're a multidisciplinary litigation firm primarily. I handle everything across the full spectrum of insurance services for carriers, including defense, coverage. I've probably got my feet wet in a number of different lines of insurance work. Primarily, I handle EPL, professional liability, coverage, and here and there we'll do some environmental work as well.
Awesome. All right, Oliver, I'll give you a 2-second soundbite here. What kind of cases do you handle?
Almost exclusively, it's products liability defense. I would say 95% of the work I'm doing is that. Mostly it's catastrophic losses from accidents involving all manner of products. Largely it's industrial products, but we also have consumer products, sporting goods, that sort of thing.
All right, cool. Well, today, litigation naturally has an adversarial element, and you come across different personality types. And if you're not a people person, at least my opinion, if you're not a people person in litigation or claims, it's going to be really tough for you. You have to know how to handle the different types of personalities. And that's really what today is about. It's when you come across these different personality types, whether it's difficult or lazy, or what are the other ones? Misbehaving. And it can really be anybody. It can be your opposing counsel. It could be your deponents. It could be vendors. It could be clients. It could be anybody you come across. And I think knowing how you deal with it ahead of time stops that reactionary, like really bad reactionary response. That's what we're going to get into today. And so Todd and Jim and I, we're trying to brainstorm what we're going to do. And this podcast stems from, I think, Todd, your post, right? Where you had that excerpt of your deposition transcript up on LinkedIn. Is that right?
Yeah, that's correct. I think we you and I had met before, online through LinkedIn circles a couple months back, but then I posted this excerpt from a deposition, gone very bad for the deponent. And I put that up there and put it out there for questions to folks in our industry about how to kind of keep calm in a very difficult situation and why we want to do that.
And I know we can't use some of the words on this podcast that were used in that deposition transcript, but you had some choice words thrown at you and you handled it very calmly and shut down the deposition because it was getting unprofessional on the other side. Is that fair to say?
Oh, that's exactly what happened. It was, and to give you the short, I guess, Reader's Digest version of the deposition, it was a high net worth individual, very confident, thought very poorly of me before he walked into the deposition, the way he was acting. Made clear during the deposition that he owned multiple homes across the world, multiple Lamborghinis. He was that type of, I guess, alpha male, at least he was trying to present himself that way. I had a great outline and a good mastery of the materials, and I knew what I was going to do, and I was going to set him up into an admission based upon the contracts. So I had moved very slowly through the deposition, setting my foundation. And the excerpt from the post that I put up on LinkedIn happened after I presented him with one of the contract documents. And we'd set the foundation. He'd made it clear that he'd read the documents multiple times and that he understood how to read contracts. He was a very sophisticated business person. And then all of a sudden you saw the gerbil running in the wheel in his head when he realized what he'd done is that he basically, he gave a catastrophic admission to his case. And I needed him to read just a little bit more of the contract, and I had passed the document over to him, and then he basically threw it back at me. And that's when he started using the choice language. And I don't want to swear on this or cuss because I think my daughter wants to watch this later. But he blew up at me. And when he first did that, I just said, "Excuse me." And then he did it again. And that's when I just made sure it was on the record. And then I ended the deposition and had to call security. In fact, what's not in the record, what I didn't post, is that he actually stood up across the table and almost came at me afterwards. And what I took from that experience is that in my younger days, when I first became a lawyer and I was, all fired up and, we're in this adversarial nature in our practice, I probably would have gone right back at him. And I think that's kind of how we're bred as litigators, is that if someone punches at you, you want to punch back harder. And as I guess I've gotten older and maybe a little bit wiser, I've learned that doesn't get you anywhere. And it's certainly not what our clients pay us to do. And I think here that if I had escalated the situation, it wouldn't have gone well for my clients. And in fact, what happened here is we got a really positive settlement for my client after this outburst, and it ended up being a good result. So I think that's what I took from it, and that's kind of why I wanted to share it with all my followers.
And that's what we talked about. So, and that kind of leads into that first personality type. We're going to talk about 4, which is the first one is the difficult one, the second one's the lazy one, the third one's the inappropriate one, and the fourth one is the annoying one. And if you guys want to add on any, you can, but your example leads right into the difficult one. I think that's the personality type we tend to run up against the most, at least I do.
Yeah.
And I share your approach, Todd. When I first started practicing, I would spit fire at fire. Like you come at me, I'm coming after you. And I probably did that for the first 7 or 8 years. And not only is that stressful, it's just so not productive. Something that I learned over the years with age and experience is if I can remain calm like you, it betters the situation for my client and for me and for the case. So let me throw this to you, Jim. How do you handle the difficult personality?
Well, the first thing as y'all were talking that I thought is, how much I love what I do as a litigator. It's thoroughly enjoyable. And by and large, at least in the area where Todd and I practice and the large we practice with here at Christian and Small, everyone else loves what they do and they get along and they respect each other. And most of our interactions are the opposite of what Todd described. When you get in a situation with a difficult lawyer or someone who's aggressive, I think these points have been made, but it doesn't advance the ball for your client. They're certainly not advancing the ball for their client, and it really devolves the relationship that helps cases move along and ultimately get resolved. When you're being aggressive, you're being unprofessional, all under the guise of trying to move the ball forward for your client. But in addition to that, it takes what we do, which I view law as not just a job, but a profession and a calling, and devalues that aspect of what we do as well. So those are some of my initial thoughts, but dealing with those people, I think you all are absolutely right. You don't go where they're trying to take you. Don't go down to the bottom with them. If you stay above, you serve your client better. You maintain your reputation, which as lawyers, what people think of us in the community is important, and we're losing that, I think. So the way we handle those people is important to our clients and to our profession.
I was lucky early in my career. I had a mentor attorney who took me sort of under his wing, and he told me that there really are two general types of litigators. You have Western boxers and you have judo experts. The Western boxer can punch you until you are knocked out, but he's got to hit you hard and hit you often. Whereas a judo expert, you don't even know what's happened until you're on your back. So you can be the little guy and win as a judo expert.
Yeah, that's a good point.
You got to pick which way you want to go, because both can be effective. But if you are an expert in judo, you'll win far more times, than if you just go toe to toe in a ballroom fight.
Can I add to something that Todd said that struck me in the way he handled his deposition? My dad practiced insurance defense litigation for 40 years, and he would always say this, but Todd seems to really have prepared well for that deposition, which really gave him the edge. Preparing your opponent keeps you from having to be aggressive and being the Western boxer, and you can be more of the judo expert in that case if you're more well prepared than the other side, and that's exactly what Todd did in that deposition.
So let me throw a question to you. If we have clients, claims adjusters, VPs of claims, risk managers that probably deal with plaintiff's counsel, claimant's counsel before it gets into litigation, and they have to deal with these personality types too. What would you say to them? What advice would you give to them, actionable advice, when they come across a claimant's attorney or paralegal that's super aggressive and difficult? Anything that you could tell them on what to do, on how to handle that communication?
I think they should hire an attorney, and they should probably call Christian Small.
After that, what's your advice after that?
I think claim adjusters would probably deal with it more than we do. They certainly have more files than we do, and so they're handling more items. And really, in most of our cases, they're going to be the end decision maker, and they're the checkbook on these cases. And so, when you get a claimant is not. It's very personal for them. And so you're going to be getting that full emotion from the claimant side. And even, with plaintiff's attorneys, they have skin in the game too. And a lot of times it's going to be emotional for them as well. I think claim adjusters, and I think they do a very good job with it, is remaining professional and trying not to get too high or too low in a discussion with these folks. Stick to procedures, stick to the procedures that have worked for you and how you properly evaluate a claim, and try not to deviate from those procedures on how you evaluate exposure on a case, and just try to remain calm when you're talking with people that are all fired up. That's what I'd say to a claim adjuster after they've hired me.
Yeah, I think that's a good advice. And I would add to that to say after they hire you. And I would say that really look, if it's a written communication and it's a super fiery one, look and parse out each sentence and figure out if there's really anything that you need to respond to. Sometimes it's just fluff and not really much that advances your claim. But if there are salient points that need to be made in response, or if they've gotten a fact wrong, or if they've sent a demand package without a demand in it, or they're saying they're sending medical records and they haven't. I mean, those are the things that you can respond to and ignore everything else. You can do a 1-sentence email response. It's like, I got your demand package, but there's no demand. Or I see that you wrote this fact, but you're incorrect. You can do that very matter of fact. And I think that's more productive than, like we all say, going at them in response. So what about you? How about you, Jim? Any advice on this to claims adjusters?
Yeah, show me the law. The one disadvantage claims adjusters have is they're oftentimes handling multiple states, and the law is different in different states. So I see demand letters from plaintiffs' counsel suggesting incorrect law in our jurisdiction, and adjusters frequently will get the law wrong or mixed up with different jurisdictions. For example, the collateral source rule on medical expenses here. Here we generally allow juries to see both the charge number and the subrogation number. Well, all the demand letters pre-suit that I see that eventually get to me have just the charge number, and plaintiffs' lawyers will challenge adjusters on that, knowing good and well if the case gets in litigation, that subrogation number is coming into evidence. So my advice for adjusters and claims handlers would be to show me the law that supports your position. All right. And then if they have a question about it, they can pick up the phone and call local defense counsel and say, this is what they're saying the law is. Can you give me a quick answer? And usually that's a 1 or 2 minute phone call for them to vet the law on that.
Yeah, I agree. What about you, Oliver? How would you recommend your clients to deal with the difficult person?
I think, as it's been said, you got to keep your head. You got to be analytical about the issues at hand. Not allow your personal distaste of who you may be communicating with to govern your reaction, because now you're the puppet and they're the puppet master. So you can't do that. I also have found in my career that your silence can actually be quite compelling on particular issues. And example, if you have a long nasty email that you're reading, perhaps you just respond, as you said, very concisely, 1 sentence. Where's your demand? Did you leave out the only really important part of this thing? The rest is just you spouting off here. We're here to talk turkey. Where's the turkey?
Yeah.
Oliver, if I could just expand on that, and from a quick story from back when I was first starting practicing, and it was going kind of on Patty's advice here is brevity. I was on a large subrogation file, and we probably had 100 people on an email chain regarding a very big and large, lengthy site investigation with experts. And one of the attorneys sent to the party that I worked for an extremely long letter, bullet pointed, bold, italics in there, all these different demands that he needed regarding an upcoming inspection. And of course, he copied the 100 or so people that were on the correspondence. And my partner responded back with no.
That's great.
And it was one of the most effective emails I think I've ever seen. I guess it's partially silence, partially brevity, but just by saying no spoke volumes of what he was doing.
We're currently in the midst of trying to get a very difficult position into mediation. We have a number of different parties, something like 15 or 20 different parties. And the only one who has absolutely no skin in the game is, constantly throwing up roadblocks to moving the case forward. So I just ignore him. I'll respond to every other person, but ignore that guy. And it drives him nuts, and I love it. So
you think he's going to be watching?
I think Oliver's going to send him this clip.
Yeah. I think he may be a little older than the generation that knows how to use the internet.
And I have a similar story where I got a nasty 3-page letter on the depositions I was looking to schedule. And I just wrote back, I'm going to do the depositions I feel are necessary. You're more than welcome not to attend. And I did an email, and then I moved on, and he was silent after that. So I do think, either silence or something that just ignores the pomp and circumstance. I don't know if that's the right word, but so, all right, let's talk about the lazy one. I know Oliver has definite opinions about this. The person that you're up against, especially the plaintiff's counsel, and I'm sure defense counsel are guilty about this too, but we're all defense attorneys, so we're going to talk about the plaintiff's counsel. But the plaintiff's counsel does nothing on their case. They file and then they disappear. How do you deal with that? I'll actually throw this to you, Oliver, first.
You just gotta push the case forward. You gotta get your motions in order and your orders from the judge. It's just that simple. We have an enormous number of what I will call highly effective plaintiffs' counsels in this city that do exactly that. Their case was built before they filed that suit, and they have no intention of doing one more hour of work on that case after filing the suit, unless, of course, the court makes them do that. And they do so at their own peril, because if they're not in fairly consistent contact with their client, circumstances can change, clients can disappear, evidence can disappear, witnesses can't be found, that sort of thing. And a lot of what we are doing is extracting this information from them and forcing them to earn their money. And it's incumbent upon us to do that, because we see a lot of it. I call it the Ron Popeil method. I think I emailed you guys that, the set it and forget it. And when I say they're highly effective at it, we have a system here that benefits them in doing that many times, because at the close of discovery, you might get a delivery at your doorstep of 30 file boxes of medical records. And if you haven't made the effort to secure them yourself, now you've got a 30-day window to hire your experts, go through all this stuff, and most importantly, tell your client what they're up against. And that never works out very well. If you're doing it at the 11th hour, you're already behind the ball.
What about you guys? Is this a problem at all for you in Alabama?
Oh, yes. I'm just like y'all, we see plenty of people who file a case and forget about it. I've got I've got our team trained pretty well to have a process in place for following up with discovery. And it's pretty automated, but I always, when it gets to the point of writing a letter, I always say, we'll be filing motion in 10 days. If you need more time, call me. So I put it on them to pick up the phone if they want an extension. Of course, I always give somebody a reasonable extension if they ask for it. But I think you've got to have your process and your team, your paralegal, legal assistant, pretty well automated, so that you push the case along. Because I don't know about your jurisdictions, but here we have 30 days to respond to written discovery once it's served. If you don't get it, you've got to write a letter. That turns into another 10 days, which turns into a motion, which turns into, another 14 days. And then the order comes probably 30 days after that. So all of a sudden you're halfway through discovery and you don't have your response. So you really got to watch those deadlines carefully and force their hand.
What about you, Todd? Any experience with that?
Of course. And I hate the hall monitor aspect of it, but in our position, we need to, and I'm sure you tell your associates this as well, document. And, you can write those letters nice. You can write those letters nicely, like we've been talking about, but they are very important to basically building the foundation if you eventually have to move forward on a motion. And I'm not really advocating email battles, because I can't stand those. And then that's going to raise the tension. But you really do need to document what you do. And we've all seen the emails, the ones you get where you basically say, as discussed today, and then you basically dictate what you said in the discussion. So at least then you have a timestamped record of it if you ever have to go in front of the judge. I don't necessarily like doing that, but I think it's good practice when you're dealing with a lazy counterpart.
And if we
go ahead.
Sorry, if we have a known habitual offender, it's counsel that you're crossing paths with regularly. I'm not going to say their names, but they have billboards all over the city, and they have ads
advertisements
on 2 in the morning. If we have those, I just tell whatever associate is assigned to the case, in your initial analysis of the case, tell the client that this is going to be a problem, and go ahead and draft your motion. Leave the dates blank. Go ahead and draft. You're going to need it. You are going to need it. You can go back and look at the last 40 cases with them and see if have they ever given you one word of written discovery that wasn't compelled by the court. I bet you're not going to find it. So go ahead and get it over with.
Well, let's look at it from the perspective of the claims adjusters too, because I hear this a ton where, pre-suit, they get a demand package and the claims adjuster or risk manager is trying to negotiate with the claimant's paralegal or the attorney, and they go silent. They ghost them completely. And then they keep trying and trying and trying to get some sort of communication flowing so that they can avoid lawsuit, but they don't. And then, day before statute runs, that lawsuit's filed and they're frustrated because they're like, I tried to talk to you about this and you wouldn't respond to me. How would you guys counsel them in that situation?
I'll jump in here. I think you've got to, what Todd said, as far as lawyers applies to claims professionals too, is you've got to document. One issue that's a big issue in Florida that is sort of starting to creep into Alabama is the issue of failure to respond to a demand, exposing you to third-party failure to settle or something like that. If they send you a demand package and you got limits of $100,000, they tell you the case is easily worth $500,000, but you got a liability question and they're not giving you the information you need to assess liability, you've got to document, here are the things I need to evaluate the case. All right, that way you're covering your rear end in case they go silent, file the suit, get a big verdict by chance or not, and then they tell you, or if they get a big verdict, you're on the hook for the excess. You can go back to the beginning of the case and say, I would have evaluated this much sooner had you given these three things I asked for from you, and here's a letter where I was asking for it. So evaluate the case based on what you have and also let them know what you don't have that you need.
Yeah, I would say the same thing. I tell them that, continue to do those emails once a month, even if it's like just following up, and just continue to do it. I know it's a pain, but it certainly helps you. And then once it gets into suit, sometimes it transfers to a different counsel, or maybe it gets out of the paralegal's hands and goes to the trial counsel. Renew those communications, see if there's a different person assigned once it's in suit, see if you can deal with someone who's a little more communicative. So, but besides that, I'm like, there's nothing you can do, right? If they ghost you, they ghost you. You got to focus on what you can control and let go of what you can't. So
make your record.
Yeah.
And carriers are in a tough spot though, because usually the demand letter is coming just to gauge and determine whether or not there's insurance. And then of course, once you get that letter, the letter from the carrier that goes back to whoever sent the demand letter, plaintiff counsel knows there's insurance. And then really the incentive there is just to file suit after you know there's insurance, because that's going to likely increase the value of your case, or at least that's how plaintiffs look at it. So we're kind of talking about a situation here with carriers where they're damned if they do, damned if you don't.
And in some jurisdictions, like in New Jersey, where you have to petition for fees in a lot of cases, where it's not a guaranteed situation, plaintiff's counsel who disappears and goes silent when a carrier is reaching out in good faith to try and resolve the case, does so at their own peril, they're probably not going to get zeroed out. They're certainly not going to get zeroed out, but they may get a lesser percentage if challenged on that issue to say, the only reason that you, quote, made this into a complicated or difficult case because you didn't respond at the very beginning. You could have wrapped it up really early. So.
All right, let's talk about the inappropriate one. And there's a lot of ways that we could go about this. So I'll throw it to you guys. Oliver, what about you? Have you ever come across inappropriate, whether it's plaintiff's counsel or vendors or deponents? Have you ever come across that? How do you deal with that?
I'll tell you just briefly, my absolute favorite one was when I was in-house with Liberty Mutual. I had, it was a very minor auto accident type rear end case. My client had bumped somebody, the typical 90 days soft tissue treatment. They're not looking to set the world on fire, even though they're asking for an awful lot of money. So we appeared for the deposition, and unfortunately I had inherited the case late in the game, and we were under order to appear. So I showed up at a unnamed plaintiff's attorney's office, and he had a woman in the deposition room that I am quite sure was being paid for her presence. If we're reading between the lines here, she was dressed exactly as Daisy Duke in the original Dukes of Hazzard. And my client was furious. She was like, this is totally inappropriate. She literally dragged me in the hall. She's like, I am leaving right now. This is horrible. And I said, we can do that, and we'll address it in motions practice, because we are under order to be here. But I can back you on that decision. However, any guy who's going to do this is probably paying far more attention to her than he is to what's going on in this deposition. And she said, all right, let's just go get it over with. He did not pose, plaintiff's counsel did not pose one cogent question in the 20-minute deposition. It was an absolute joke. He was completely befuddled. And we left there, and I think it resolved for some trivial amount, less than another dep would have cost. So that's my favorite one. But sometimes the inappropriateness, you just let him run. You know, my granddad used to say, you give him a rope, he wants to be a cowboy, and then he looks ridiculous. So that a lot of times that works. However, I'm not advocating that anybody allow themselves to be abused on the record. There is a line to be drawn.
Yeah, I used to get in depths like Babe and Honey. Maybe, do you guys ever get that? I don't know if it's
all the time.
I got Babe and Honey when I was younger, not so much when you're older. I guess that title goes away. And I would just address it. I would say, please call me Miss Baxter, or, you know, and then I'd move on, and I kept doing it, and I just ignored it. But what about you guys? What kind of inappropriate stuff have you seen, and how do you handle that? How about Todd? I'll throw it to you.
Sure. You know, I'm dealing with a very difficult plaintiff counsel on a slip and fall case. I've told Jim about it. I'm not going to give his name, but he's older. He's been around the block before. He thinks he has a mastery of the law, and it does not matter what I do in a deposition with him. He is going to raise objections that have no merit, and I have to keep responding to them. Now, you know, I grew up practicing in Chicago, taking depositions in Chicago, where we all kind of ignore the speaking objection rule. We take it seriously down here in Alabama. You know, no speaking objections. The counsel keeps, you know, trying to do speaking objections, and then just going on and testifying, and then making objections which make no sense. And then if I was to call the judge in the middle of the deposition, which I really do not like doing, I would almost feel silly making that argument to the judge because the counsel was in such a wrong position. So I think this is kind of going with our theme that we've been talking about here today, is really just trying to let those things roll off of you. Stick to your plan, stick to what you're trying to do. You've been prepared, you know the facts, and try not to, and these are just tactics too, right? A lot of these times they're just trying to get under your skin. They're trying to get a reaction from you. They're trying to get you off of that end goal that you have. And so you got to really we have to, as lawyers, we have to fall back on our training, fall back on our experience, what we've been told by senior attorneys in our career, and really just try to, as Jim keeps saying, move the ball forward. And how is this going to be helping our client?
What about you, Jim?
Yeah, I think inappropriate is a very broad term, but you know, there are rules we have in terms of professional conduct that are more than just you know, inappropriate comments that are personal. But the speaking objection one is really important. You know, ex parte contact with judges is something, you know, that you see sometimes in smaller venues where everybody seems to know each other. And you really got to hold people's feet to the fire. And a lot of times these people who, and I agree with Todd, it's a tactic a lot of times, but use these tactics, do it because nobody has stood up to them. So, you know, I find sometimes with, like, if I get, for example, in a deposition, we have our usual stipulations allow you to object to the form of the question, and you can assign the evidentiary grounds to the objection later. So a lot of times if someone objects, they'll just say object to form in the deposition, and you move on, answer the question. Well, sometimes I'll do that. And although they're not required to assign grounds, I'll just say, what's the basis of your objection so I can try to ask a better question. And then they're like, oh, blah, 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 blah. They come up with no rule under the rules of evidence that's the foundation for their objection. So, and lo and behold, once you do that, they stop objecting the deposition because they really don't have an evidentiary or discovery grounds for the objection. So even these inappropriate ones, I think, there are times when you've got to let it roll off your back, but there are times when you need to stand up to them a little bit and do what a lot of people don't do, and that's remind them that this is not okay with me.
Yeah, and I would say when I'm in a situation when you have like either a deposition or some sort of on the record proceeding, especially with a court reporter present, they normally have their stenographic equipment, but they also usually are recording it for their when they go back and they do it and they can hear it, make sure they got it right. I've had situations where the plaintiff's counsel went off the record, and that's where the written record, and that's when the inappropriate either words or conduct happen. And I said to the court reporter, please hold on to your audio recording. I'm going to subpoena that later. And then you attach that to a motion so that they don't get away with going off the record and doing whatever they're going to do. We also had, and Oliver can jump in on this, we recently had an issue where, we had a pro hoc counsel. Plaintiff is pro hoc in Pennsylvania. He's a New York and New Jersey attorney. And in Philadelphia, when you pro hoc in and you go into court, you have to have your local counsel present with you. That's a rule. You can't just pro hoc and show up by yourself. But he did that. He showed up by himself, and the attorney handling it was like, where's the local counsel? And he was like, well, are you going to object? And she's like, I have an ethical obligation to tell the court. And he got really mad at her because she went up to the court crier and said, I'm okay with proceeding, but I feel like I have an ethical obligation to tell you that these rules aren't being followed. And the court crier was like, no, absolutely not. He cannot argue. And he was so mad at her. And I said, oh, you did the right thing. Like, you have to call out sometimes inappropriate stuff because you don't have a choice. You're an officer of the court. You have an ethical and legal responsibility to do things. So I think there's some time where inappropriate behavior you have to address. You don't have a choice. So that's my 2 cents on that.
Yeah, you don't want to be dragged down by someone else's bad behavior. And in that instance that Trish and I just experienced, it's not a question of would we stand in the way of this pro hoc counsel giving oral argument, because who cares? He can argue if the court's going to let him, but we are not going to become complicit or accomplices in him breaking what's a pretty significant rule. I mean, essentially, it's practicing law without a license. That's a problem. It doesn't seem that big, but that's what it is.
Yeah. Well, let's ask, and I'm going to venture into a little bit of a taboo subject maybe, and maybe you guys want to comment or not, but what have you ever had clients be inappropriate? And how would you handle that? Any takers? Or are we going to stay away from this question?
I could give a story, and this was a case involving fraud, misrepresentation, and the embezzlement of money. And it wasn't my client. I was representing a family member of who I guess was the main defendant in the case. Was this older lady who had taken money from an estate, and she was gambling with it to the tune of millions and millions and millions of dollars. She was gambling with it, traveling all over the country in private planes, and she was denying it. And she, she was in the deposition. She was very good in her deposition, but she denied it. But for some reason, because I was representing her son, she seemed to like me, and she seemed to want to share information from me, even though I didn't have that attorney-client relationship with her. Well, there was one time in the middle of her deposition when we had all taken a break, and all the other counsel walked out of the room, and I was just sitting there on my computer, checking emails during our break. And then she just told me everything that happened in the case and everything that she did, everything that she was fighting within the questions from plaintiff's counsel. And I just had to look at her, and she basically just told the whole case to me. and I was just like, you got to stop this right now. I'm like, I appreciate you. You think you trust me, and you can trust me personally, but I'm an attorney here in this situation. And I didn't really know what to do. So I had to go, I think my next thought was I have to go tell her attorney what was told to me, because I have this information. It's not privileged, what she told me. And I told the attorney, he handled it, but it was one of those really odd situations where I was given information that I really shouldn't have been privy to. And it was really because it's just one of those inappropriate kind of once in a lifetime situations that I'm sure we all have our own stories like that in our practice.
Mm-hmm. I've been fortunate enough. I've really never had anything that sticks out at me from a client perspective as far as inappropriate. I've had, as I don't know, maybe if you guys have this as men or not, but I know all women have this issue when they go to conferences and there's alcohol involved and there's prospective clients there. I've had issues with prospective clients that, take it and want to take it further than just a friendly discussion. And you have to know how to navigate that. And I feel like I do know how to navigate that, but I've been lucky. I've never really had anybody ask me to do something I wasn't comfortable with, or maybe they asked me and I'm like, no, we can't do that. And here's why, but I've never had that, at least not that sticks with me. Oliver, how about you? Have you ever had any situations like that?
Nothing terribly extreme. Usually it's a case of, the client perhaps wanting to overly police what documents are produced, not necessarily hiding things, but the idea is, well, this couldn't possibly be relevant. Well, that's not really the issue at this point in discovery. We have directives from the rules of civil procedure, and we have in many cases a case management order, and sometimes a discovery order that we have to comply with. So we'll turn it over, and then we'll sort it out later in litigation, whether it's admissible or usable for any real purpose. And once you explain that to them, they're usually pretty good with that. Some of them require more convincing than others, particularly just a year or two ago, I had a client who developed an extremely important piece of medical technology, perhaps one of the biggest inventions of the 20th century, imaging technology. That technology was stolen in about 10 to 15 years before our litigation, and was put into actual use. The allegation of loss of revenue was into the billions of dollars because of that. So basically every piece of technology that they don't build is a clone, and they lost all that money. And so they were extremely reticent to give even me as counsel any pieces of or any documentary evidence that we needed to produce in the case, much less allow me to turn that over during discovery. That took a lot of convincing, and we had to actually get an order from the court, which is fine, and I understand their position, but that's sort of the area of that I've come across. Nobody has given me an indecent proposal. Sorry.
Not yet, right? You never know. One could come tomorrow.
I guess. I don't know.
All right. Well, let's talk about the last one. This may be a little overlapping, but I do think it's important, and it's not something that's all that difficult to deal with, but the annoying one. Whether it's the plaintiff's counsel that emails you every day, or the vendor that emails you every day or calls you every day. Do you guys ever see any issues with that? And I'll throw this to, how about you, Jim? You want to give this one a shot?
Yeah, I've got one plaintiff's lawyer I deal with. He's probably a good lawyer, but he has a high volume of cases. His only negotiation strategy once it's in suit is to call you it feels like every week. It's probably once every 3 or 4 weeks to say, hey, I'd really like to get this resolved. I made a big move last time. I think haven't heard from you. Well, I won't name his name, but Mr. Plaintiff's lawyer, the last 3 times we had this call, I told you I need to get your client's deposition. Our offices are scheduling dates. I think we got on the calendar for 2.5 months from now, but nothing has changed and nothing will change until I get that. So, as tempted as I am to sometimes just hit send a voicemail, I do still take those calls from him. But it can be frustrating, and it's, from my client's perspective, it runs up their bills a little unnecessarily because they got to spend 15 minutes on the phone with him and then let the client know. He called again, same demand, nothing's changed. But those can be frustrating because they're really not moving the ball forward. You know, that can be difficult, but sometimes you just have to deal with that and not lose sight of the end goal, and that's getting the discovery you need to analyze the facts and the law and evaluate the case.
How about you, Todd?
I don't know if I'm qualified to speak on this topic because I'm concerned that I might be the annoying one myself. You know, we talked about following up and documenting and making phone calls. And that's, I've been told by attorneys that I do that a lot. And that, you know, and when I was an associate, I would have conversations with the senior partner that I work for saying, well, the plaintiff's counsel is getting a little frustrated with your emails and following up and these things. But that's really the only way I know how to practice law, is to stay on top of things and keep pushing things.
So you're the annoying one.
I probably am, and I'll run with it. And I'm fine with that. I'm pretty confident in my own shoes, but I think I'm probably an annoying one. And I imagine some of the attorneys who practice with me who are watching this might say that. I try to keep it polite and friendly, and you know, a lot of times when I'm following up on things, I'll preface it with like, you know, I'm sorry, I got to keep doing this, or, you know, it's just in my nature where I got to follow up. Like I'll try to preface my annoying correspondence or annoying follow-up calls like that. But, you know, I guess I'm the annoying one. And sometimes I feel like our clients pay us to be the annoying one.
Yeah. I think for that, I would label you as the persistent one. How about that? I think you can probably change that for a positive. But yeah, I think, you know, for me, I like when I get the annoying one. It shows weakness, I think, to some extent. If they're constantly calling you, asking for X, Y, and Z, maybe more so on the, give me a, you know, I need an offer, let's mediate. If I get 10 of those calls, I'm like, all right, let's do this, because they are wanting to settle the case. They're hungry. But otherwise, if it's stuff that I can't do, I may take the phone call once or twice. Jim, I give you credit. After that, I do hit send a voicemail, because I'm like, I don't want to deal with you right now. I will call you when I have something to report to you. But that's my take on it. How about you, Oliver? What do you do?
Yeah, I agree. It sort of smells of a softer position when they're consistently asking you, basically, well, when are you going to pay us? You know, nothing again. And when nothing has changed, there's been no significant movement on the case. Why are you asking me for money at this point? What I find to be the most annoying is not the constant phone calls, is not the constant emails, although those are very annoying. I find annoying these sort of, sometimes they're veiled threats, but more often than not, they're direct threats. Like they'll say something like, we're setting this up for a bad faith claim. Well, based on what? On, you know, even if there's 100% liability, your demand is ridiculous. We have a defense as to damages. So what's your basis for this? That to me is, unless it's a true bad faith, and there are a handful of those do exist. But when I start to see that as the knee jerk, we see that a lot in like the New York litigation. It's like, this is bad faith. No, okay, you're now going to voicemail until something in the case changes. You know, when there's positive movement, meaning more discovery, more evidence has come in, something, or even a change in the law, something that would change the position, the balance in the case. That's my most annoying thing. Is this now you're threatening me? Okay.
Yeah, they take an unreasonable position, or, you know, and they keep hammering that unreasonable position. That can be a little bit frustrating. All right. Well, listen, anything else to add on any of our personality types? Any stories, any war stories before we wrap it up? Anybody?
We could, but
I know we all want to, but we're all cognizant of the fact they're being recorded, and this is going to be out there. I would love to do one where we were not being recorded, or not thinking that we're being recorded, and see what we really say in the language that we really use. I would use some choice language, but all right. So let's finish up with some takeaways on personality types that we can leave for our clients, right? The adjusters, the general counsel, the risk manager. What do you pick one, or just to have a general comment? And I'll throw this. How about one of you guys? One of my Southern gentlemen. How about one of you guys?
That's Jim. It's not me.
All right, we'll go to Jim first.
Well, I'll take the reputation even though I haven't earned it. But, I think once it's in litigation, one of our jobs as defense counsel is to sort of screen the ridiculousness from the claims professionals that we're dealing with. I can handle the excessive phone calls. I can handle the aggressive lawyer deposition. And my job is to still boil down the facts in the law and set all that aside and let them know what the case is worth on liability and damages and help them make an assessment. So, I see that as part of why we've been hired in the first place is to help them do their job better. So we deal with the ridiculousness. We deal with the people who are lazy, the extra phone calls, the failure to get discovery on time and push the ball forward. So I would say just keep your eye on the prize and don't get distracted by people wanting to drag you into the mud.
All right, what about you, Todd?
I think it kind of encompasses everything we've talked about today. And even when we were first talking about that post I had on LinkedIn is stay even keeled and don't let the highs affect you too much. Don't let the lows affect you too much. And no matter what's thrown at you and how it's thrown at you, try to stay even keeled and don't let it affect you. We're going to be practicing for too long, and it can take too much stress out of you to let it affect you. So stick to your guns, stay even keeled, and try not to get caught up in the chaos and the mess.
And I'll comment on that too. When I see the difficult personality and how worked up they get, sometimes I'm like, God, they're gonna have like an early heart attack. Like if they keep this up, their health is gonna be affected. And I see them, and I'm like, thank God I abandoned that after year 7. I would say I'm a much more pleasant person. I can't imagine just taking everything and being so worked up about it. But Oliver, what about you? I'll give you some the last takeaway here. What would you tell your clients?
You do you let them do them. Stick to what you know. Be your person. Speak to people the way that you want to be spoken to, which in some people it's formal, some people it's casual, but reflect who you are in your communications. And don't be the puppet. Don't take the bait. If someone is trying to draw you in to an unnecessary battle, don't let them do that. Not only is it bad for you personally, it wastes time and money for your client. You don't have to win every single battle to win the war. You got to win most of them, but just focus on what what your goal is in the case, and you should know what that goal is from the very beginning. And that's a whole other podcast, is determining that.
Yeah, and I think the overall thing, and what I love about this episode and what we're talking about it is, if you have a plan in place on how you're going to deal with this type of person that comes across your path, if you have that plan in place, it's so much easier to know how you're going to react, right? I was guilty of, I got that, blustery email and I would just type right back. And now I'm like, just put it aside, think about it, let it 24 hours pass. I have a plan, and it helps me, not to take the decision out of how do I respond. I know how I'm going to respond. So such an important episode. Great tips, you guys. I'll just leave it with a couple things. One, if you like the podcast, please hop on, subscribe, hit, a 5-star review, leave a rating. We would love it. And then Jim and Todd, where can people find you? I'll throw this to you, Jim. If somebody's looking for you, where should they look?
Well, Christian and Small, Birmingham, Alabama. We're in all parts of the state and Mississippi, and then we've got handle some matters in the Panhandle of Florida. Obviously, LinkedIn. If you want to go see my family, you can go to Instagram. Both of those are Jim Patillo, all one word. And then our, you find us through the Christian and Small website. Easy to Google and find that. So I appreciate you having us and really enjoyed the time.
That's awesome. I'm so happy. How about you, Todd? What do you want to say about where people can find you?
Well, you can find me 2 doors down from Jim. And I'm also on LinkedIn. You can find me on LinkedIn. That's how we met, actually. I remember when we started first communicating. So I'm really glad that you offered to bring us on your podcast. It's really been fun speaking with you and your partner, Oliver. And thank you so much. And hopefully you'll invite us on and do it again sometime.
Yeah, absolutely. I
Yeah,
love this. This is so fun and easy. So, all right. Well, listen, thanks guys. I appreciate it. Thanks for listening, guys. Until next time on The Defense Never Rests. We'll see you then.